So, good afternoon, dear members of the panel and all participants here and far away. Don't know how far though. So we're opening the afternoon session with 5 speakers, and we start with Elena Stojić, I guess. And you are from here?
Yes.
From the University of Belgrade. And you're speaking about the 2 failed legal transplantations in the Civil Code of Serbia. The floor is yours.
Hello, everyone. Hello, everyone. My name is Elena Stojić, and today I will be presenting the 2 failed legal transplantations of the Code Civil in Serbia. Before I start with explaining the reasons why the Code Civil failed to transplant in Serbia, I would like to say a few words about the French Civil Code. During the First French Empire, Napoleon I had dreamt of restoring the Roman Empire, and we can see that he had big ambitions of restoring the old glory of the Roman Empire by observing the fact that the French government structure was extremely similar to the Roman government structure. The French had consuls, they had a senate, they had a tribune, and they also had the emperor, which was Napoleon himself. Napoleon I also preferred to call himself the democratic Caesar, to which shows us how much he respected and admired the Roman Empire and how much he wanted to bring France to the same level of glory that the Roman Empire had. So that's why in 1804, Napoleon I formed a committee of 4 respected jurists who made the first draft of the Civil Code. The team worked on the code for 4 months, and after the drafting process, the code went through a complicated legislative procedure as it had to go through the council, the senate, the tribute, and the legislative body. But in the end, it was enforced on the 21st of March in 1804. And while it was enforced and in use in 1804. In 1807, it was published again, but this time it was named as the Code Napoleon, so both names can be used interchangeably depending on the circumstances. It is also important to note that the Code Civil itself isn't a completely original text, since it was heavily inspired by the Corpus Juris Civilis, which was made by Justinian I during the Roman Empire. So we can see that there were a lot of elements of Roman law that had integrated itself into French law. Nonetheless, the Code Civil still had some new legal norms pertaining to certain legal ambiguities, so it was some sort of a mixture of French and Roman law. The Code Civil is regarded as one of the most important Code Civils of the 19th century, even though, for instance, it wasn't the first. The West Galician Code, published in Austria during the 18th centuries, was almost published a whole century before the Code Civil. But what makes the Code Civil unique is that it was written in a very simple, precise, and concise way that even normal people who weren't jurists by profession and who had no legal knowledge were able to understand the text which was represented in front of them, and that made the Code Civil as the model for many civil law codifications across Europe. And one of the countries that were inspired by the Code Civil were Belgium, the Netherlands, parts of Italy, and Germany, since they were under the occupation of the French Empire, and numerous French colonies such as Egypt, Tunis, Morocco. It is very interesting to note that the Code Civil also had an influence across the Atlantic Ocean, in America, in the USA, and in Canada. For instance, in Quebec, Canada, and Louisiana, the USA, French law had integrated itself as a base for those regions. Even though today there is a mixture, it is the common law is more dominated in those regions, but still there are some elements of French law. In order to understand why the Code Civil had failed to transplant itself into Serbia, I think it is important to explain what was actually happening in Serbia during the 19th century. During the 19th century, Serbia was under the command of the Ottoman Empire, And during that period, Serbia was fighting for its autonomy against the Turks. And there was a first and second Serbian uprising. The first Serbian uprising was led by Đorđe Petrović, also known as Đorđe Petrović. He had the nickname Karađorđe, which Kara means black in Turkish, and the origins of his nickname is uncertain, but there are many stories as to explain why the nickname was given. His main objective was to gather as many political allies in order to help the Serbs combat the Turks. And he sent his men to ask for Austria for help, to which Austria denied in helping. They also asked Russia for support against the war, in the war against Turks. They were uncertain. They said that they couldn't help them. In the end, Karađorđe leaned to France to ask for support. And he did so by sending one of his captains, Rade Vučinić, to give Napoleon a letter in which stated that if France were to help Serbia against the fight among Turks, that that Karađorđe would allow Napoleon to occupy some few small Serbian cities. And he even went as far as to order the Code Civil to be translated in Serbia for it in order to be used in Serbia even. But despite the offer, France denied helping Serbia because they wanted to maintain good relations with Turkey. And they were too preoccupied with the war going on with Russia and Austria, so they were unable to help. And that attempt at gathering Napoleon I as a political ally actually represents the first failed attempt of integrating the Code Civil in Serbia. After the first Serbian uprising failed, the second Serbian uprising happened, and it was led by Miloš Obrenović. Since many men fled Serbia after the failure of the first Serbian uprising, Miloš Obrenović was among the few men who stayed and thus gathered the support and trust of the Serbian people. He was considered their leader, and he negotiated with Maraš Ali Pasha, Ottoman governor who had the role of vizier in Belgrade. He negotiated with him, and he managed to give Serbia partial autonomy while still being under the Ottoman Empire, and that was considered a big success for Serbia, considering the fact that the first Serbian uprising failed. And Miloš Obrenović ruled Serbia during the first half of the 19th century. During his reign, on the initiative of the Serbian people, the process of drafting a civil law codification began because the Serbian people, during those times, Serbia was in a state of political instability, and since many of the Serbian laws were outdated for that time, there simply rose a need for them to have a new civil law codification, and that's why in 1829 Miloš Obrenović formed a legislative committee, which was known to the public as the Zakonodatelna Komisija. And one of the more notable members of the committee during its early stages were Vuk Stefanović Karadžić and Georgije Zahariadis. It is important to note that many of the members of the legislative committee weren't educated in the legal field, which made the whole process of drafting the code significantly harder, and it took a longer period of time for it to become enacted, to become published. As I mentioned, one of the more notable members of the committee was Vuk Stefanović Karadžić. He was a Serbian linguist and philologist who was also known as the father of Serbian folk literature. In his letter, it is stated that he was quite hesitant to work on the committee, but despite his hesitancy, he still provided to do his fair share of duties. Alongside Vuk Stefanović Karadžić, there was also Georgije Zahariadis, whose picture I couldn't find, since there is not a lot that is known about him. But he was a Greek man born in Tirnavos, Greece. He was educated in Greece, and after he finished school in Greece, he moved to Zemun, Serbia, where he worked as a teacher. And after working as a teacher, he was also promoted to the principal of the school in Zemun. He later on met his wife, Katarina Mihajlović, with whom he had 4 children with. And after they started a family, they moved to Šabac. In 1829, Miloš Obrenović sent a letter to Georgije Zahariades offering him the job of translating the Code Civil into Serbian. Georgije responded to Miloš's letter stating that he was honored and that he has accepted the task and that he promised to do his best in translating the work. There are some scientific claims which state that Georgije Zahariades' translation was horrible and that was the reason why the legal transplantation process failed. But despite those facts, there is research that states Georgije Zahariades spoke fluent German, Serbian, and Greek. Since he was born in Greece, we can agree with the fact that he was fluent in Greek. And since he lived and taught in Zemun, Zemun's one of the official languages in Zemun was in German. So he had to speak German in order to teach his class. And he also wrote many books in Serbian. So we can all collectively agree that Georgije was all fluent in all of those three languages. And his translations, since his translations were not available, they were lost. They're not available today. We can come to the conclusion that his translations was probably well done, and that his translation was probably well done, and that it wasn't his fault that the legal transplantation process failed. And we can come to the conclusion that the most probable reason why the legal that second attempt failed is because the inadequate work of the committee as a whole, and that there were many, again, political instabilities which deferred the work process of the committee as a whole. And that's why, after 10 years of the first try of legally transplanting the Code Civil, in the year 1837, with the approval of the Austrian government, Miloš Obrenović summoned Jovan Hadžić and Vasilije Lazarević to join the legislative committee. But sadly, due to the passing of Vasilije Lazarević, Jovan Hadžić was left to work alone. And Jovan Hadžić had promised Miloš Obrenović that he would use the Code Civil as the main source and that he would also use Serbian customary law. But he then came to the conclusion that Serbian customary law was very outdated for today's needs, and that the institutes that the French Civil Code had contained were too foreign for the Serbian people. And that's why he suggested on using the Austrian Civil Code as an example for the Serbian Civil Code, as the model for the Serbian Civil Code. It's also important to note that Jovan Hadžić was a famous Serbian writer, poet, and legislator. He was most famous for founding the Matica Srpska, the oldest Serbian science institute. And I would also like to state the fact that he was born and raised in Sombor. He finished his primary education there, but after finishing his primary education, he enrolled in a German school in Sremski Karlovci, which after his enrollment in Sremski Karlovci, he later went on to study philosophy in Pest. And we can notice that since he was studying in the Austrian Empire, we can conclude that he was probably most familiar with Austrian legislation and the Austrian Civil Code. That's maybe that could be one of the major reasons why as to why he chose the Austrian Civil Code as the model for the Serbian Civil Code. And in the end, the Serbian Civil Code was enacted on the 25th of March in 1844. And today actually marks the 180th anniversary of its enactment. And it is a great honor for me to present this subject in front of you all. So that makes this even more special for me. And the act of publishing a civil code during the 19th century in Serbia was also represents a significant success, considering the fact that the whole time Serbia was fighting for its autonomy, and Serbia was relatively a small region which had little to almost no support against the fight in the Ottoman Empire. So I'm very proud that my ancestors were able to do that. But since the first days of its publishing and enactment, the Serbian Civil Code was met with a lot of backlash and criticism. The reason why many Serbian jurists were disappointed with the fact that Jovan Hadžić completely disregarded Serbian custom law when it came to making the codification. There is a famous Serbian-Hungarian jurist, Pavle Šeroglić, who stated that he only copy-pasted the Austrian Civil Code onto Serbia, completely disregarding Serbian tradition and the Serbian mentality. To later on, to Šeroglić's critics also joined Dimitrije Matić, a famous Serbian law professor, who didn't critique Hadžić for the fact that he copied the Austrian Civil Code, but he was quite critical about the fact that he diminished women's rights when it came to inheritance law, because women and men in Serbia during the 19th century were treated equally, but in the Austrian codification, women had a slightly inferior position when it came comparing to men when it came to inheritance. That's one of the main reasons why Dimitrije Matić criticized him for that. Also, one of Nikola Krstić also criticized his work, stating that he completely disregarded the Serbian mentality and that Serbia was in need of a new law codification. And because of such harsh public backlash, the Serbian Ministry of Justice launched the revision of the Serbian Civil Code in 1872. And they surveyed many judges and jurists and came to the conclusion that the Serbian Civil Code, which was written by Hadžić, was adequate for the Serbian people, but it was in need of slight alterations and amendments in order to fill some gaps and provide new legal norms in certain aspects. Also, one of Slobodan Jovanović, a famous Serbian jurist, was also one of the many people to criticize Hadžić for copying the Austrian Civil Code. And when we, and in summary, Jovan Hadžić was remembered as someone who was heavily criticized during that time, and who simply, he just tried to do his job, but the Serbian people were not satisfied with it, even though Borislav Blagojević he did a revision process of the Serbian Civil Code and came to the conclusion that the Serbian Civil Code contained elements of the Austrian Civil Code and the French Civil Code, since Hadžić himself said that during the when he was encountered with certain legal ambiguities, he consulted the French Civil Code. And that is something that is sometimes disregarded, because most people say that he only used the Austrian Civil Code, while in fact he also did use the French Civil Code, but to a small extent in comparison to the Austrian Civil Code. I would also like to state that despite the French and Austrian Civil Code, the Roman law also had an effect on the Serbian Civil Code. It is unknown whether Hadžić himself directly used the sources of Roman law and applied it to the Serbian Civil Code, or if the fact that Roman law is integrated in Serbia is so integrated in Serbia as a whole, because Serbia was under the command of the Roman Empire for centuries, that it is just simply a part of Serbian culture. It is still unknown to this day whether he had used directly Roman law or just used Serbian law, which was inspired by Roman law. But nonetheless, it is still obvious and indisputable that Roman law had a major influence on Serbian law. For instance, the institute Animus Domandi or Actio Pauliana is something that is still evident to Serbian law this day. Canon law also had an influence on Serbian law in regards of family law and certain legal norms that define marriage, and the Serbian Civil Code also contains elements of Sharia Ottoman law. For instance, in property rights, the institute miljak is mentioned as an immovable object, or the preemption, or in obligations, the preemption right is also mentioned. So it had numerous sources of inspiration. So the Serbian Civil Code had numerous sources of inspiration when it came to its drafting. I would also like to mention the work of Alan Watson, who states in his work that sometimes law codifications can consist of multiple sources of legal loans, and that sometimes the country that is selected to be the donor of legal transplants can be selected by pure chance, which raises the question, what if Jovan Hadžić had been educated in France? Maybe if he had been more familiar with the French legislation process, with French institutes, maybe he wouldn't have been so hesitant to apply certain French norms in the Serbian Code Civil when it came to its drafting. That is a question which is very difficult to answer, but I think that is important in this day and age. It is important to observe and question the source of legal transplants when it comes to drafting and making new legislative norms. So that's it.
We're discussing immediately. I mean, for 5, otherwise it would be too long. It'd be the speech and question, I would say. We will. I mean, I wrote down a lot of things, but
okay.
But please, reactions.
I would.
We should leave the finger on.
Oh, sorry. I would like to also mention the comments. What's the name of the Hungarian jurist?
Pavle Šerolić.
The Hadžić's response to Šerolić's comments was that his knowledge of the judicial sciences was student-like, which is quite an interesting response to critiques. But yeah, I don't know if you read by Sim Abramović paper. He did.
Yes. It was too long to include it in this presentation, but I'm writing a scientific article, and I plan on mentioning that in the article. Thank you.
Other reactions? So it's my turn. Thank you very much. I learned a lot. And it's very stimulating. Of course, you spoke of so many things that it's a bit like the legal transplants of Alan Watson. You speak of many things in a very small, short short lapse of time. Yeah, well, about the reactions, I was wondering, the Galician code you spoke of, was that the one of von Martini?
Yes, the West Galician Code, which was published in Austria, I believe, in 1797.
Yeah, that's right.
Yeah.
This is why. Okay, I wondered why you mentioned this one particularly, because it was just a preparation actually for the ABGB.
Well, I wanted to. It was, maybe that's my fault. I wanted to state that despite being the most influential civil law codification, it wasn't one of the first. It was revolutionary.
Yeah, well, you had the ILR pollution code 1 year earlier, and yeah, it was not influential at all either.
Yes, and I wanted to state that despite something being revolutionary and groundbreaking and influential, it doesn't have to be old in a way. It can be.
I don't know whether you read Weigert and Kurtz about it. They have some theories about why the French code was so much more influential than the Austrian code or the Prussian code. And they link that, well, to the French Revolution and the fact that in Austria, when they had this modern code based on natural law, in the end, they considered that it had nothing to do with the Austrian society, because there was equality in the civil code that did not exist in Austrian society. So it was kind of a theoretical code that was not implemented in the real life. And that made a difference with France. And then, well, Napoleon, like him or not, had some aura that no one could match in Austria.
A certain authority.
Yes, yeah, of course, it is a dictator. I mean,
Yes, an emperor.
again, I said, like him or not.
Yes.
It's very weird that people continue to like him even today, but because he's a mass murderer. But yes.
Yeah, I agree, but
But at that time,
when
obviously,
it came to Serbia for asking the support of many nations, they didn't consider their personalities. They only wanted help regarding the political aspects. So they were quite desperate during the 19th century.
I was also very interested by this Georgios Zachariadis.
Georgios Zachariadis.
Yeah, that I'd never heard of him before. But it's an incredible period for Greece too, because that's the time of revolution and against the Ottomans and when their own independence was. And soon afterwards, the Greek also had a translation of the Code Civil in Greek. But yeah, I checked the timeline. So Zachariadis was before the translation into Greek. And so I don't know whether Zachariadis was the one also that translated the Code Civil afterwards for the Germans in Greece, but
I'm actually not sure, since regarding all of our subjects and our faculties, we are not. Georgi isn't mentioned. He's maybe mentioned in one sentence in our textbook, and my mentor provided me many great sources. Although they are limited, they described his biography to a certain extent. I tried, because as I mentioned, some authors state that his translation was inadequate, but that statement does sound ridiculous considering the fact that since he worked in Zemun, he knew Serbian, he knew German. It is to me.
He knew French because he had to translate from French.
Oh, I'm sorry, I forgot to mention. He translated the German version of the French Civil Code. I'm sorry.
He took the one from Baden then.
Yeah. Yes. I'm so
he
sorry.
took from Zachariah von Lichtenthal, I guess. That's interesting.
I was quite nervous during my presentation, and I accidentally omitted the fact that Miloš Obrenović himself sent the.
Don't worry, I mean, I'm not.
The German, but I think it is important to note that he was working on the German translation of the French Civil Code.
But that must have been written very early because it has been applied in Baden already since the beginning, since 1804, if I'm not mistaken.
I'm not quite exactly sure, but I know from the work of Sima Avramović and Zoran Mirković, our dean, that they did. They stated in their work, so I used that work as an inspiration since they're high authorities.
And about the conclusion to Alan Watson, I mean, the choice of the donor being by mere chance, well, probably yes. And with the time in the 19th century, it happened even more. I don't know whether you know that book, the Correspondance de Saint-Joseph. Have you heard of that?
No, I haven't. I'm sorry.
So I'm just letting you know what it means. I mean, it has been very much used all over the world and probably mainly in South America. There have been 2 editions. Actually, it would put in parallel columns the articles of every known civil code just to compare which rule was written. So, I mean, when you were about to draft a civil code, it was quite obvious to go and do your shopping in this book. Yeah. I mean, it has been used very much. I believe that in the 2nd edition, the Serbian Civil Code is included in this comparison. So, of course, when you start making books like that, you should be surprised to have some article shopping and pick just the rule like you like it. So, well, thank you very much.
Thank you for your questions.
So, I suppose we're moving to the second presentation. Is it you? Okay, yes. So you are Milan. Blagojević.
Yes.
Sorry for my pronunciation.
No problem. No problem.
And so the title is The Influence of the Position of Serbs as a Minority in the Austrian Empire on the Contents and Language of the Serbian Civil Code.
Yes. Can I
You have
start?
it, Prof.
Thank you. First, we should start with some background. To say that the 19th century has been turbulent time for Serbia would be an understatement. Only recently gaining any semblance of independence from the Ottoman rule, it left the newly formed country in much of a dire position where they lacked almost everything from legislation, bureaucracy, modern army, modern economy, infrastructure, educated professional, and etc. So these problems required a big effort to address, and they were slowly addressed one by one. What's interesting is that the leader of the second Serbian uprising, Miloš Obrenović, had a much more diplomatic approach toward his way of gaining independence, and was much often keen on fighting battles on the negotiation table than on the battlefield. He was also pretty ambitious and wanted to leave a mark of himself as a great leader, so he ordered creation of a Serbian Civil Code of a way to modernize the fixed Serbian legislation and push Serbian bureaucracy further. Why was this so important? Because Serbia, as a relatively newly formed country, brought a fourth codification of this type on the European continent pretty early on in its reform existence after centuries of occupation. And this was extremely ambitious task that he wanted one man to do, Jovan Hadžić. Why is it interesting that Jovan Hadžić did that? Jovan Hadžić is not from Serbia, he is from Austria. And the fact is there were almost zero to none educated professionals in Serbia. The way they solved this was by sending Serbian bright students in Europe to be educated, but this obviously took time. So at the beginning, when Serbia gained some sort of autonomy, many educated Serbs who lived as a minority in Austria started to move back in Serbia because they had an extremely strong connection to Serbian people more than to Austrian people. Why? And this is seen in the fact that a man who lived as a minority in a very developed empire left his home to go back to Belgrade, which was not very developed. It was a region that was pretty ignored by Ottoman rule and was often a center of many wars between Austrian and Ottoman empires, with many casualties, especially after the First Serbian uprising. Shows us the great patriotic sentiment that was shared on both sides of the Danube. Bit of context for the Serbians who lived in Austria. They were there for a long time, few generations from the 17th century. They were brought there after the defeat of Austria and the Austrian-Ottoman War, but patriarch of the Serbian church, Arsenije III Čarnojević, and they lived there in a pretty better conditions than compared to the Serbs in the Ottoman Empire, where they had much more opportunities in life, religious freedom, didn't have the fear of persecution, but they had obligation toward the Austrian Empire in this organization called Vojna Krajina, where they were needed to defend the border in case of Ottoman invasion and serve in the army. We can see how much better position they had with Jovan Hadžić himself. He was extremely educated man, son of a rich merchant from Austrian Vojvodina. He studied philosophy in Pest in Hungary. He got a doctorate in law in Vienna, so he was more than educated in Austrian law. And he was an active member of the Serbian community, forming Matica Srpska, the biggest Serbian institution 20 years before he wrote Serbian Civil Code. So we see this clear connection between this minority and who lived a much better life than the Serbian minority in the Ottoman Empire. Also, one other interesting connection between the Austrian civil codes. No, excuse me. I started with the wrong paragraph. When he made the Serbian Civil Code, he was criticized by many people that it was a mere translation of the Austrian Civil Code, that he was forcing upon foreign values on Serbian people, and then it was a waste of time and pretty bad job, lacklusterly made. Which was not true. This has been disproven by modern science and contemporary researchers, because we see that he created a unique Serbian characteristic and identity of this legal document. It is the reason why it was in use for 100 years. And there were also many other influences besides Austrian Civil Code. There was canon law, there was bits of Ottoman Sharia law, there was Roman law, there was bits of French Code Civil in minimal amounts, and we see this especially in language, and in size of the documents. The Austrian Civil Code is much bigger than the Serbian Civil Code, and it uses much more of a professional language compared to the Serbian counterpart. We also see this in language used to describe issues of citizenships. In certain articles, Jovan Hadžić does not refer to only Serbian citizens, but Serbs in general. And there was this part when every Serb must over his brother, his other Serb. I didn't have time to translate it into English. This refers to a more national sentiment, which was present in the Serbian Civil Code, much more natural law-like compared to the more objective and more, how would I say this, neutral Austrian Civil Code. This was because both Jovan Hadžić and the leaders of Serbia were more than realized that Serbian people were greater than Serbia itself, and there was still work to be done, and there was still desire to encompass the larger Serbian diaspora into this newly and still developing Serbian state, which is why they pushed for this national sentiment in the Serbian Civil Code. What also is likely that the way he changed Serbian customary law was probably because he wanted to push Serbia farther toward Europe, and because Serbia was bordering Ottoman Empire on the south and Austrian Empire to the north. Austrian Empire was Christian European, and it was obvious that they're going to look more towards a more Christian European neighbor than Ottoman Empire. I don't think they were planning on transplanting Ottoman law into Serbia. This was also one important thing, which was a connection between Serbian minority and Serbia, was the connection on canon law, especially with canon law in regards to marriage. The Serbian church had a huge role in keeping the national identity of Serbs in Austria. The leaders of the church often served as representatives of Serbian people on the Austrian court, and led the negotiations for Serbian schools and for them to even gain access to live on Austrian land. And so was outlined by Professor Sima Abramović in his work. There was a huge influence from canon law in regards to marriage in Serbian Civil Code, which was put there probably by Hadžić, probably to make a bridged connection between Serbia and Serbian people outside of Serbia, because church, as seen in many other cases, such as with Poland, often holds national identity of its people when there is no nation itself. And this in conclusion, shows us that the Serbian Civil Code was a step forward to making a stronger, independent Serbia and to make a country that would be more than a home towards the rest of its people when they unite with its huge diaspora in its bordering empires. Also, one thing I would like to mention, but I didn't have time to properly research, was the fact that the member of the committee for translating the French Code Civil, Vuk Karadžić and Jovan Hadžić, were rivals in terms of linguistic reforms of Serbia in the 19th century. And because one of the critiques that Jovan Hadžić got for his Serbian Civil Code was that the language he used was much unprofessional and crude, was, in my opinion, probably because of their feud in terms of linguistic sciences. And this would be it. Do you have any questions?
Please. Yes.
Hello. First, thank you for the well-presented work. And I have a question. Was there any, since you were talking about the influences on the Serbian Civil Code, how they interpreted, included many elements of different forms of sources. Was there any elements of natural law in the Serbian Civil Code in contrast to the Austrian Civil Code, since Austrian Civil Code was more influenced by positive law, by positive practices? So were there any changes in that direction in the Serbian Civil Code?
Yes. What I read from, the ideas of natural law came through Austria, and it was it resonated much with Serbian people because of this sense of identity. I didn't. You could see that I was talking about that the language used was especially in the limitations of the Duke, which was the beginning of Serbian Civil Code, is much different from how the Austrian Civil Code opens up. And yeah, I didn't had time to dig into that topic, but I probably will. But you could see it in these limitations and the universality of laws. Also, what's interesting is that Serbia abolished slavery in 1904, which is extremely early, and I don't think, and you could see it also in Montenegro. We are going a little bit off topics here, but yeah, Gorski Vienna has some elements of natural law, if one could say so. Yeah, that's a bit of a. Yeah, I mean, yeah, and also what I also forgot to mention was that what's also the Elena said earlier about the Roman law. Hadžić was educated in Latin, and I read somewhere that he was more than capable of reading the original sources in Latin, so that's probably where also he had his influence. And also Serbia was in a unique position. Balkan is an extremely multicultural region, so of course it was shaped by the ever-changing peoples and nations that moved through the peninsula. And even though Serbian state didn't exist for long, Serbian people existed, and they were influenced by these different law practices they were under for a few generations. Yeah, thank you. My apologies, I forgot to. I overlooked that.
Okay, more comments or questions? Otherwise, I would say that we are in the middle of Alan Watson, and every presentation is really nice because we've been discussing of matters of Volksgeist, of legal transplants. And actually, in the two first presentation, I had the same idea about how difficult it is sometimes to point out, well, that rule we have in the Serbian Civil Code comes from Roman law and does not come from French law. It comes from, I don't know. Well, if there is Roman law and the French law, then you could wonder. And then we have the question of authority also. Then you say, well, actually, I don't want my code to look like the French code. So even if I take the same rule, I would pretend that it's from there. And you have that very much in many countries. It's quite funny. I mean, in Alan Watson's book, there is this explanation about the Civil Code of Louisiana, which is really interesting. And then you have that discussion, and you have, what is it? What's his name again? I forgot the name of the two. There's Pascal, and the other is... anyway, they analyzed every single article, and one says, well, it's basically French, and it's not the Code Civil, but the third draft of Cambacérès, and the other one says absolutely not, and then he makes a list of, well, that's from Potier, that's from Spanish law, that's from, and you have a completely different list. And it's quite funny because they're speaking of the same articles, and they analyzed every article. Makes me also think about, well, when China and Japan considered to draft a civil code, well, it was difficult to admit that they would copy a European code. So they do prefer sometimes to say that the civil code is from Roman law, because that's an authority they can accept, because it's not an existing state anymore. So it makes it much easier. And anyway, Alan Watson is very present today. I'm very happy about that. And if it's okay, I would turn to our third speaker, which is Đorđe Gojković. Is that right? And it's about comparison of interest regulation in the Austrian and Serbian Civil Code. The floor is yours.
Thank you, Professor. I'm very thankful to speak today, and especially happy seeing some familiar faces, some traditional guests here with us today. So, as you could guess, we are staying on the Austrian Civil Code, a very popular topic today. And I will speak something about the comparison of interest rate regulations between the Austrian and the Serbian Civil Code. So the Austrian Civil Code, as we heard, is amongst the most significant codifications of modern European civil law. Its importance is widely recognized by lawyers, by historians, and especially the legal historians. So the general characteristics of the Civil Code will mostly fall out from my paper. The primary focus herein lies on comparing the regulations governing interest rates between the Austrian Civil Code and its Serbian counterpart. So the Serbian Civil Code was adopted in 1844, marking it amongst the first civil codes in Europe. However, the only European countries to have an original civil law codification in a modern sense of word were countries like France and, of course, Austria and Bavaria, and Serbia falls into a second category alongside other nations such as Netherlands and Swiss cantons, which basically adopted one of these original codifications with, of course, some transfigurations. So Jovan Hadžić, as we also heard from my colleague, was a prominent Serbian lawyer and an intellectual, and he was appointed to write down a code based upon the existing statutes, customs, and traditional tradition, let's call it tradition, of the Serbian people. And so after 6 years of what appeared to be an investigation of so-called national spirit, Volksgeist, as the professor mentioned, and circumstances in which the people lived in, he came out with a text of a new civil code. However, it was a legal text which at first glance resembled of a shorter version of the Austrian Civil Code. But the only thing was, at the time, they thought, is that instead of the ACC's 1,502 paragraphs, it was 950 paragraphs long. So for a long time, prevailing opinion amongst the scholars was that summarizing of the Austrian Code was not done critically and carefully enough. Hence, the Serbian code is not systematic and clear enough. We could hear some of the critiques my colleague has mentioned, but relatively recent work has shown that the creator of Serbian Civil Code has been much more original than it was initially thought. While the foundation was indeed borrowed from the Austrian Code, the Serbian Civil Code integrated legal principles and institutes from various laws, such as we mentioned it, Roman law, canon law, Ottoman law, and of course, Serbian customary law. Most notably, normative differences are evident in family and inheritance law, and the vastly different social context between the two countries made Hadžić to draw inspiration from, first off, Serbian customary law. However, disparities in contractual law emerge, including the regulation of interest rates. Both civil codes define a loan contract as an agreement in which one party transfers ownership of a certain amount of consumable and replaceable goods to another, who then agrees to return the same amount of goods of the same quantity and quality after a specified period of time. Agreeing on a loan fee, or that is interest, is allowed, but only within the code's regulations of the interest. So the main differences lie in the maximum allowable interest rate. The Austrian Civil Code, in paragraph 994, sets the maximum of 5% for collateral loans or secured loans, and 6% for unsecured loans. The same goes for the interests that are agreed generally without a certain amount, and paragraph 995 proposes a 5% statutory interest except for obligations arising from merchant contracts, when it is 6%. Serbian Civil Code, on the other side, imposes 6% statutory interest while permitting contractual interest rates up to 12%. Knowing that most contracts in both civil codes are basically the same, more or less the same, the question arises, why did the Serbian lawmaker find the Austrian regulation inappropriate, to say so? So charging interest was, as we know, always a hot topic. And from the earliest time, philosophy, moral, and religious teachings mostly condemned the practice. It was not unanimously allowed all the way until 19th century. The ideal world was shattered by the extension of trade and industry throughout the Middle Ages. One of the key factors in developing tradition regarding the interest was, I argue, religion. Both Serbia and Austria were Christian countries, of course, greatly influenced by the church in the medieval period. History of Serbian interest rates shows us that the influence of the Orthodox Church was crucial. At first, it forbade charging the interest altogether, but medieval Serbian states were mostly rooted in the Byzantine version of Roman law, and they started practicing usurious loans early, the loans with interest. Serbian Church took a rather conservative attitude towards interest rates, but as the economy grew, the prohibition seemed to be less and less effective. So from the time of Emperor Dušan, it's mid-14th century, according to the theory of symphony between the church and the state, middle ground solution was found by prohibiting the clergy to charge interest altogether and allowing civilians to charge interest while maximizing or limiting the interest rates up to 12%. On the other side, Catholic Church mostly forbid charging interest altogether. During the medieval, the scholastic denunciation of usury was suited to a self-sufficient agrarian society in which loans were primarily for consumption purposes. After the Great Schism, usury, often mistaken for interest in general, so usury and interest were consecutively used as terms, was officially condemned by the Second Lateral Council in 1139. In the following century, for example, Pope Innocent IV expressed a fear that, quote, the countryside would be deserted because peasants had become usurious or had been deprived of their cattle and tools by landowners themselves attracted by the profits of usury. More of such usury condemnation can be found in works of theologians and saints such as Saint Bonaventure, Thomas Cobham, and especially Thomas Aquinas. However, that didn't stop the medieval bankers and merchants from finding countless ways to evade clerical injunctions. Leaders concealed interest behind euphemisms, so interest was hidden by such terms as quote, yield, gain, reward, rent, profit, fee, and foregone benefits. By the early modern period, the distinction was made between consumer and commercial loanings. So interest on consumption loans was still condemned as usury, but charging for the loan of productive capital was increasingly acceptable. So it can be concluded that the Orthodox Church has made a compromise with the, let's say, reality of economic and social needs earlier than the Catholic Church, and the disparity in attitudes towards interest may explain the difference in regulatory approaches between the two civil codes. Of course, it's not the only factor, because social and economic context was obviously very different in two countries, and basic economical reasons says that the lower interest rates promote greater access to credit, which stimulates economic activity. Well, there's no doubt that Austria was, of course, much richer at the time than Serbia and was experiencing a rapid economic growth. It was driven in part by a robust agricultural sector left over from the Middle Age, which could be a factor in favor of low interest rates, because of course agricultural investments require less capital and they carry much lower risks than industrial or commercial ventures. Hence the demand for capital was relatively low. Serbian lawmaker, however, besides tradition, just might wanted the opposite. He maybe wanted to discourage the borrowing because of serious problems Serbia had with people indebting in the first half of the 19th century. For example, two rulers' decrees depict the situation. In the first one, from 1836, Miloš Obrenović forbids that the creditor must not charge an insolvent debtor's household. The following year, ruler has kept the interest rates to 12%, being worried that a new economic class of usurers may emerge. Death of peasants was such a huge problem that many witnessed that a loan to just celebrate the feast. The feast is a literal translation. Some of you may know Slava, the Serbian custom. So just to celebrate the feast, the Slava, according to the customs, could after a few years emerge to such a debt that the debtor had to sell his whole household to return the money to the lender. Having this in mind, it is quite likely that the lawmaker wanted to maximize the already high interest rates, but still discourage the borrowing to everyone who is, let's say it like that, who is not that needy to take a loan. So until more factors are examined, I presented just a few potential factors between in comparison of the two codes that could lead to differences. And it seems as the creator of Serbian Civil Code was highly aware of the different social contracts and legal traditions, contrary to what's usually believed of him. And as I'm looking forward to deepening my research, I will conclude with a quote of a famous Austrian economist who kinds of justifies the low interest rates. And it's not that this is a point or conclusion, but I just want to provoke the discussion, because Eugen von Bembaverk says that the higher a people's intelligence and moral strength, the lower the rates of interest. So tell me, what do you think about this? I have my own opinion though, and I'm awaiting the questions, the critiques, the commentaries. Thank you once again.
Should we vote for or against the last proposal? Who is in favor of that link between intelligence and rates? The smarter, the lower the... Nobody. Well, let people answer. You gave your own answer. Nobody. Is that true? Are you? That's a funny one. Yeah, but please just. Yes.
Just a short question, more of a comment. You mentioned the social aspect of the capping of interest rates at 12% in the Serbian Civil Code, and this is completely and understandably a legitimate position, given that there were several other institutes in the same time which were also introduced to Serbian law to prevent the peasants from getting on the wrong end of the debtor's stick, so basically losing everything, their entire household, to the usurers. And one of them is the protection of the household, basically creating a landowner's minimum which cannot be indebted, which cannot be given to the usurers, which could not be sold even if the person is completely under debt. So how do you comment on the other measures that were taken by the Serbian government from Prince Miloš's time and onward to protect the Serbian peasants from the high interests?
Thank you, Đorđe, for the remark. I mentioned the decree of Miloš Obrenović of the household, and I think that those are the arguments going in favor of what I'm talking about right now. So it's that social context that needed the interest rates to be kept at a certain maximum, and it happens to be that the maximum is the same one which Serbian tradition is, let's say, used to since the Middle Ages, because we see nowhere the higher interest rates kept neither in the Middle Ages and or the modern times. Thank you.
Another question, comment? Yes, please.
I hope people online can hear me now, because I was told this other microphone didn't work. So regarding the same subject, really, there are authors who really praise this measure of Miloš Obrenović in protecting the poor peasants from the evil moneylenders and so on. But there are also authors today who condemn this policy because they say that it slowed down the development of credit investments in Serbia and generally the banking sector, and that was bad for the economy and so on. So what's your opinion generally? Was it a good thing or a bad thing globally, not just for the individual peasants?
Well, it's hard to answer by yes or no, but I'm indeed more on the side of those who are not more on the traditional side of supporting the measure, because even today you can't expect people to know everything about the credits. And imagine that, imagine Serbian 19th century peasant in such situation. He was not aware of the obligations he was supposed to fulfill by taking the credit. So I'm not quite sure that it would speed up the economy or the banking sector that would eventually emerge if people just lost their houses.
Another one?
One, I don't know how much is this related, had the problem with interest, and how the Professor Nina said Miloš's desire to protect innocent Serbian peasants from evil money launderers. Had that any connection with a strong gambling problem that was present in Serbia in 19th century, and loans people took to gamble? And did you encounter that in your research?
Thank you for the question. Well, yes, there's certain mention of gamble and spending monies at kafanas, the very famous Serbian institution. But I don't think that everyone who lended the money spent them at kafana or on gambling. It's just logically it couldn't be true.
No,
But
they took the loans for purpose of gambling. Was that mentioned in the in your research, or
I haven't encountered such situations or their relations to the capping of interest rates. Thank you.
Okay, if I can just add something or a question. Do you know who the bankers were and how influential they might have been? I mean, I'm saying who because we know that in Roman times, the bankers were Greek. Later in the Middle Ages, very often they were Jewish. So, I mean, you mentioned religious problems. So was that one of the issues? And if they were not, have they been influential as a group, as a lobby? And the other question would be, well, were there eventually different inflation rates between Serbia and Austria? I mean, if you have much higher inflation in one country than in the other, it seems quite obvious that the interest rates must be different.
Thank you, Professor, for the questions. To answer the first one, as far as I know, bankers were not the different religion from the money lenders. So I think that's not the root of the problem, as far as I know, because there's mention of mostly the Serbs lending money to each other. So there's not such problem, because I understand the question as in the Middle Age, we had religions not prohibiting the charging of interest, and we had the religions that would prohibit interest rates. But I think that that's not the situation in 19th century Serbia. And on the inflation, well, of course, I think that we had different inflation, and especially when you look at the time when the civil codes were enacted. One is in 1811, so Napoleonic Wars going on. But I don't think that the codifiers, the lawmakers, had inflation in mind when capping the interest rates, because it's the civil code is made, in my opinion, at least how I would make or create the civil code. I would make it to last more than to outlive the current situation, which could perhaps show, for example, high or low interest rates. So I didn't really have that in mind when I was doing my research, but I think that's not the main reasons of the difference between the capping of interest rates. Thank you.
Okay, thank you very much. Yes, George.
If I may, one nota bene on the question of interest rates and the question of inflation. Serbia, in the years that it passed its civil code, it's in 1844, it will be another quarter of a century, so 25 years before Serbia gets its own currency. So in that time, Serbia used a mix of Ottoman and Austrian currencies. So that's basically leaning towards the position that Đorđe just stated, that inflation is a non-factor in this broader analysis of the topic.
Thank you.
Okay, then if there are no more questions, I would consider that we should carry on. And I wonder whether Isabela Wasik is present or not.
Yes, I am online.
Wonderful. So I don't see you, but I hear you.
Okay.
So the floor is yours.
Okay, dear ladies and gentlemen, distinguished professors, distinguished colleagues, I would like to express my sincere gratitude for the organizers to take part in this conference. I hope it's visible.
It's starting. Yes. Well, we see your WebEx now, not the presentation. Yes, here it is.
Okay, thank you very much. So, in the beginning, I would like to give you a brief introduction for the most important legal solutions of the Habsburg monarchy in the second half of the 19th century, so that in the following part of my speech, I will be able to familiarize you with the solutions for struggling against usury. To the beginning of the transformation of the Habsburg monarchy into a state under the rule of law can be seen in the issuing for the October Diploma in 1860. Interestingly, the authors of this act was the Pole Count Agenor Gojković. Based on the federalized tendencies, the Imperial Act regulated the exercise of the legislative power by the Emperor and the Parliament, that is the Council of the State, and also the national duties. The October Diploma established a presumption of the competence in favor of the national diets, taxativity, defining matters reserved to the Council of the State. This included particular matters relating to the state's finances, including taxation, post, telegraphs and railways, and the military service. The October Diploma met with different reactions. Poles and Czech welcomed it with a great hope for the further process of federalizations of the state and the acquisition of the wide range of the autonomy in the future. The changing situation in Europe annihilated a recognition of the Franz Joseph I's domestic policy direction. Imperial Minister Anton von Schmerling applied the basis for the Act, so-called February Patent, next year in 1861, later issued for an imperial patent. From a formal point of view, it was an act implementing to the mentioned October Diploma. Centralism was taken as the start point for the individual solutions. Not surprisingly, like the October Diploma, the presumption of legislative competence was shifted here to the Council of the State. In addition to February patent, national statutes were then issued for the individual countries in the monarchy. The national statute from Galicia specified the competitions, powers, and the scope of action on the Galician Diet in quite some detail. The scope of the subject matter jurisdiction of the Galician Diet was indicated. These were mainly matters relating to the national culture, public buildings, and charitable establishments maintained with the local funds. Areas relating also to the general law, like municipal, ecclesiastical, and the school matters, also the provision of waterlogging, supplies, and accommodation of the army. The executive body of the Galician Diet was the Galician Department. Also, we have the General December Constitution, which consisted of 5 laws with the imperial sanctioned date of the 21 December in 1867, and namely the law of the judicial power, on the exercise of the governmental and executive power, on the establishment of the state or core, and the universal right of citizens, and last but not least, the February Patent Amendment Act. And at this point, it's also worth taking a moment to consider how the discussion related to the usury issue was held in the national diets. And in the picture, you can see also the national Galician diet in Lviv. Lviv was the capital of the Galicia, of the Kingdom Galicia and Lodomeria, name officially. The beginning of the discussion was around the second half of the 19th century. Members pointed out that the usury was a significant social problem, bringing many farms in the countryside to the ruin. The problems was even sometimes compared to the cholera epidemic. It was pointed out that the difficult position of the farmers was often exploited, for instance, the impoverishment of farms due to epidemics and the other natural disasters. Illiteracy and the impossibility of accurately verifying signed contracts were also a serious problem. The lack of support system and the wider access to the credit institutions, for instance, credit advance societies, were also highlighted. The press of the time also took a keen interest in that topic. The discussion then moved to the Vienna Council of the State. The work carried out from 1874 onwards finally resulted to the issuing of the law combat to the usury in Galicia and Bukovina. However, it should be noted that already at that time individual deputies indicated that it would be appropriate to issue all law for the whole of Austria, not only for the just one crown. In that case, it was a Kingdom of Galicia and Lodomeria, and the final results were the passing of the law in 1877. It was called an Act on Remedies Against Unfair Conduct in the Law Agreements. It was an extremely short regulations. The Act provides for the penalties for persons who granted a loan in the knowledge that the other part would suffer some material damage as a result of such agreements. For instance, exploitation of uneducated persons, or as indicated was in the Act, weakness of mind. They could be sentenced to the imprisonment from 1 to 6 months or fine of 100 to 1,000 Rhenish zloty. If someone was professionally engaged in such procedure or convicted again, then the penalty could increase and the arrest could be up to 2 years. The law also provides for the possibility of annulling such contracts act if the terms of such person has been taken advantage of by criminal courts. In principle, criminal courts were capable, but civil courts also were allowed to operate if, for the reason other than the lack of sufficient evidence or the lack of substance of the act, criminal proceedings could not be conducted. Interestingly, in the case of evaluation of evidence, the judge was guaranteed by a slightly greater freedom to access the evidence, and the emphasis was placed on deciding but the judge's conscience. Both press and judiciary were pleased with that introduction of that law. Shortly after, in 1879, this matter returned to the Council of State in Vienna. The Austrian and also the Moravian national duties also expressed warning about the problem of usury. Therefore, discussion of the fight against usury started at that time already in the whole Austria. It was decided quite quickly that the basis for the law for the whole part of the Austrian part of the Habsburg monarchy would be law passed in Galicia. It was finally modified a little bit, and then in 1881 a new law received imperial sanction and covering the territory also from Austria, from Galicia and Bukovina, and we have the law against dishonest proceedings in law contracts for Austria, and it was slightly longer law than for the previous one. Penalties was also imposed on people who granted loans and at the same time took advantage of their lack of experience and lead to, as it was indicated, property ruin. At that time, it was possible to be sentenced to imprisonment from 1 to 3 months or a fine of 100 to 500 Rhenish gold zlotys. In addition, if sham contracts was conducted, it was possible to be sentenced to imprisonment for also exclusion of the town. In case of second conviction, the penalty of imprisonment could range from 3 months to 1 year or a fine of 500 to 2,000 Rhenish golds, also with the possibility to exclusion for the town. Also, based on this law, the criminal code could annul this action. These solutions turned out to be quite permanent, as the change did not place in the Habsburg monarchy, the Austrian part of Habsburg monarchy, until 1814. And in conclusion, cases in which solutions developed in one crown country would affect the law on the entire monarchy was quite rare. The above case was also somewhat unique. For here we did not have the reception of the solutions worked out by the national diets, but the state Council for Galicia. Subsequently, there were solutions somewhat modified and introduced throughout the whole state. Nevertheless, it should be aware that the beginning of this discussion dedicated to the fight against usury took place in the National Diet in Galicia. After all, there were also deputies representing Galicia in the Council of State in Vienna. In the end, it was not only the statutory regulation, but also development of many critical societies and credit unions, which became quite active in the next few years, and that all efforts contribute to the reduction of the large scale of the problem, like it was usually in the Habsburg monarchy, not only in Galicia in 19th century. And from this point, I would like to thank you very much for your attention.
When we applaud and the microphone is all shut, then she doesn't hear that we applaud. We did applaud.
Thank you very much.
Okay, well, reactions, comments, questions? I don't see any hands raising. Well, it was obviously another legal transplant, interesting, going from Lviv to the west, to Vienna. I must say I have no real comment about this because, well, it was all very clear. So I'm afraid that we're running out of gas.
So thank you very much for your comments, and I really appreciate all the day conference. So,
well, thank you very much again, and well, we will move on then to Laszlo, Adam, sorry, Joe, how you call it? Yo. That's good. The circumstances of a unification process, Hungarian private law, the returned eastern and Transylvanian parts of the country, and you are from Debrecen.
Yes.
Please, you have the floor.
Honorable professors, dear colleagues, my name is Laszlo Adam Jó from the University of Debrecen, and my research topic is the legal system of the territories returned to Hungary in 1940. In this presentation, I'm going to speak about the circumstances of the unification process following the Second Vienna War, with special regard to the legal sources. Until the middle of the 20th century, Hungary did not have a civil code in force, and several areas of the private law were founded on the judicial practice. However, this judicial practice became more and more written, mainly through the decisions of the Royal Curia, the highest court of Hungary. Excellent legal scholars crafted drafts since the turn of the century. 3 of them were submitted to the parliament, but none of them were accepted and brought into force. In 1928, it seemed that the first private law code of Hungary would be adopted at last. Nevertheless, it never discussed. What were the reasons of this neglect on the side of the legislator? I need to mention that the proposal was too progressive for the conservatives, and at the same time, it was too old-fashioned for the liberals. The Great Depression, beginning the next year, also contributed to the withdrawal from the agenda. Moreover, there was an important reason in connection with the territorial losses of Hungary. As a consequence of the Peace Treaty of Trianon, Hungary lost the 2/3 of its previous territories, and more than 3 million Hungarians who lived outside of the new borders. However, the majority of the rules of private law remained in force in the Slovakian and Subcarpathian parts of Czechoslovakia, and Romania and Yugoslavia. In the 1920s and 1930s, millions of Hungarians lived in the hope of alteration of the borders, which was not fictitious in the light of the developments. From this perspective, several people were worried about the unity of private law among Hungary and the disannexed parts of the country. According to that argument, if the proposal had been adopted, it would have broken the connections in the field of private law and led to a so-called private law trianon. Among others, Bálint Kolozsvári, the dean of the Faculty of Law of Budapest, supported this position. In contrast, Lajos Tóth, the rector of the University of Debrecen, argued that the proposal was mainly the compilation of customary law, not a completely new code. Therefore, it would have been applicable in the disannexed parts of the country as the source of the private law. Both of scholars were the professors of private law. Although the proposal was never adopted by the parliament, it became the part of the judicial practice due to the fact that the courts referred to its rules in their judgments. This situation was not unprecedented in the Hungarian legal history, because the Tripartitum by István Verbőci and the Provisional Judicial Regulations from 1861 also prevailed in this way. 10 years after the submission of the proposal, Hungary started to re-annex its previous territories from the countries in the neighborhood, where the significant part of the population was Hungarian origin. The parliament empowered the government to take all measures considered necessary in order to reconnect the system of private law to of the re-annexed territories to the legal system in force in the rest of the country. On this ground, the government adopted several decrees in order to extend the scope of Hungarian private law to there. Following the First World War, the majority of the rules of private law remained in force there, and they were still in force at the time of the re-annexations. Therefore, the unification process did not require greater efforts, but this statement does not regard to all the territories. In Transylvania, several rules of the Austrian Civil Code had been still applied. Before I start to present the problem of the extension of Hungarian private law to northern Transylvania, let me give some information about the legal historical antecedents. Following the suppression of the War of Independence, in 1853, Francis Joseph I brought into force the Austrian Civil Code in Hungary and Transylvania. Although in 1861 it was almost completely repealed in most parts of Hungary by the Conference of the Justice of the Realm, in Transylvania it remained in force, but later acts replaced to a certain extent. It should be noted that the Austrian private law was a compulsory subject for law students in Hungary too, until the end of the Second World War. After the First World War, Transylvania and the eastern parts of Hungary were annexed to Romania, but the private law was mostly untouched. On the 30th of August in 1940, northern Transylvania and other regions, at that time parts of Romania, were reunited with the Kingdom of Hungary through the Second Vienna Accord. At the end of 1940, the problem of the unification arose again, but in a different way because of the ABGB. The above-mentioned Bálint Kolozsvári recommended to set up a commission with the task of laying down the new rules of the Northern Transylvanian private law on the basis of the proposal and private law code. The work of this commission would have been similar to the Conference of the Justice of the Realm, which constituted the Provisional Judicial Regulations in 1861 to bring back the Hungarian norms instead of the Austrian rules. In contrast, Rudolf Schuster, the former chief judge of the Hungarian Patent High Court, would have brought into force the proposal in the whole country within a few years after its reconsideration. He was a Transylvanian origin lawyer who applied the ABGB as a young judge, and he knew the advantages of a code in contrast to the customary law. The government preferred to full integration as soon as possible. Therefore, it adopted several decrees in order to extend the scope of Hungarian private law to these regions, as in the previous cases, in the case of the territories which were returned from Czechoslovakia. I have to mention that Károly Stojić, one of the most respectable private law professors, supported this solution from the beginning. He correctly foresaw that the proposal would have been acceptable after several years. However, the unification was urgent. It should be noted that the authorization of the government did not extend to bring into force those rules which were not in force in Hungary. Despite this solution, the proposal had an important role in this process. At first, the scope of the law of real estate was extended, followed by the law of persons, matrimonial law, and the law of obligations, all of them in 1941. In the next year, before the matrimonial property law, inheritance law were brought into force, the Bar Association of Marosvásárhely, nowadays Târgu-Mureș, Romania, had written an open letter to the Ministry of Justice in which the lawyers stated their objections against this measure. Here, I would like to highlight two objections and denote my position based on my research. According to the first objection, Hungarian private law was not codified in written form, so it would have been very difficult to have its rules made accessible to the population of Transylvania. Besides, excellent summary works were published in journals, and the 6th-volumed Hungarian private law, edited by Professor Stojić, was completed in 1942. Professors at the Francis Joseph University of Cluj-Napoca gave lectures on the extended laws and afterward issued them in a book. The second objection referred to the fact that statutory law would have been replaced by customary law. Thus, the stable framework established by the ABGB would have been replaced by a system of customary law, which is much more fluid by its very nature. Extending the normative complex of customary law to the territory of northern Transylvania by a degree of government would have been impossible, because it did not live in the public conscience of the Transylvanian people, which is not even in concordance with the legal sentiment of those people, and which was not used there for decades, maybe ever. The resistance was not against the unification of law in general, but against customary law in particular. Against these arguments, I have to declare that the extended customary law was founded on written sources. Several rules of the proposal were applied in the mother country, and the judges also referred to the academic literature, especially the sixth volume Hungarian private. However, greater role was given to the decisions of the royal curia. The Supreme Court of Hungary was empowered to create the so-called decisions in principle, decisions of legal unity, and decisions of full session since 1930. The latter two had the power of obligation on all courts, while the first one only bound the councils of the royal curia, significantly affecting judicial practice of the lower courts, hence the customary law. They also refer to the non-priority judgments of the highest court, although there was a huge overlap between the judicial practice and the customary law. The countrywide obligatory decisions did not fall under the second category, in contrast to the decisions of principle and the non-priority judgments. In consequence, all of them were not only written sources, but they were well-known and applied equally throughout the mother country and cognizable in the return territories. Moreover, in 1853, the ABGB was a completely unfamiliar code for Transylvanians, and the extension of Hungarian norms was inevitable for the purpose of the integration. Furthermore, the ABGB became somewhat old-fashioned by 1942 because its amendments came into force in Austria at the beginning of the 20th century, but not in Transylvania. The government did not accept the arguments of the Bar Association and decided in favor of the full unification of the law, which was consequence of repealing the ABGB. The unification process was completed in the next year by the extension of the norms regarding the matrimonial property law and inheritance law. Thus, the system of private law rules of Hungary generalized, the ABGB being definitively repealed from among the sources of private law, following almost 90 years being in force. This solution seemed to be not the most appropriate one for the unification, but the sole possible one among those circumstances. I admit that it would have been a more appropriate solution to bring into force a Hungarian private law code, but it was not possible because of the Second World War. In 1942, the point of view was formulated in the literature according to which, by repealing the ABGB, a legislative vacuum formed in northern Transylvania because of the transplantation of customary law had formally taken place, but the content of the new law as brought into force was not known. Hungarian customary law, formally in force, now had in fact to be created by its very application by the Transylvanian judges. Following the analysis of the decrees, the rules of Hungarian and Austrian Transylvanian private law, contemporary periodical articles and judgments, I came to the conclusion that the organically developed but non-codified Hungarian private law was better applicable than the codified but old-fashioned Austrian Transylvanian private law in the 1940s. I strongly affirm that in spite of the initial fears, legal professionals, especially judges, could confidently apply Hungarian legal sources. As you can see on the slide, they often refer to the decisions of the royal curia, but there were also several citations to the rules of the proposal as a source of written customary. One of its causes was that many judges from the mother country were appointed to Transylvania. Thus, they could give assistance to the Transylvanian kings. In autumn of 1944, the Soviet and Romanian armies occupied the eastern and Transylvanian parts of the country, and the Romanian legislature extended the scope of the Romanian Civil Code, which was based on the French Code Civil. Despite that, it is worth doing research on this topic, as the experiences of this unification process could be valuable when the legislator plans to implement a new rule or a complex of rules respecting the legal certainty.
Okay, thank
Thank
you
you
very much.
for your attention.
Okay, the last round of comments and questions. Yes, please.
I know that the Hungarian Communist Party was pretty active in this period. Did they play any part in this story that you told?
The unification or the occupation of modern Transylvania?
Oh my God, I'm sorry, my brain stopped. The legislation,
No, absolutely not. There were no members of parliament in the National Assembly from the side of the Communist Party, only from the side of Social Democrats. So this Communist Party was banned in Hungary in this period.
after the revolution, probably.
Yes, after the revolution of
1990.
1919, yes.
Thank you.
Other questions? Yes.
Was there any area of law in which the extension was particularly seen as problematic? Because a recurring theme both in Watson and in other authors is whether the more personal areas of law, such as family inheritance and so on, are harder to transplant or not. So I'm just curious, what was the situation in this area?
So as I mentioned, these two fields of law were the most completely other than the Austrian Civil Code. So the most discrepancies were shown between these two fields of law according to the ABGB and according to the Hungarian private law. For example, the acquisitio conjugum. So the succession of branches, for example, which is the special part of the Hungarian inheritance law, was absolutely unfamiliar. The code, the Austrian Civil Code. So I think it was the cause that these two fields of law were extended to northern Transylvania at the end of the unification process. So the other fields of law, matrimonial law, law of persons or obligations, were extended as soon as possible after half a year or 1 year after the occupation. But these two fields of law only in 1.5 years after the occupation.
Thank you.
Okay. More comments, questions? I'm just wondering otherwise, are you doing this research also in connection with colleagues from Cluj, or is that on your own and without any direct link to them?
So there's a Hungarian university in Cluj-Napoca, Transylvania, the professors and the lecturers of that faculty can help me a lot, and they help me a lot by.
So the answer is yes.
Yes.
Okay, you can elaborate more on this just to make sure, please. I didn't want to stop you.
So they can help me. I usually and always read their sources, their essays, their books, and the new legal history of Transylvania. It's a new book, monography, bulletin of the legal history of Transylvania. It's a really valuable source for me. But mostly I use my own sources from the National Archives of Hungary in Budapest. For example, those judgments which were created, instituted by the courts of Transylvania in this period of time, and after that they were given to the royal curia.
Okay, thank you very much. So I'm just having another look whether someone is still alive. And well, you look alive, but still, I think we will call it a day and say that it was a very nice day. Thank you to all of you, also those who had the patience to listen to my talk in the morning. And we'll see you again tomorrow, I guess.
Thank you, everyone. So see you tomorrow at 10 for the second keynote lecture, and then we continue with 1 session in English and 2 in Serbian tomorrow. For those following online, the link stays the same, so see you tomorrow.
Thank you very much. Have a nice day.
You too.